Good morning, everyone, and thank you for attending the Oxford Arbitration Day. My name is Ana Dallagnol, and I am one of the co-organizers of the event. We are now starting panel number 2, the view of the client, in which experienced professionals will be discussing aspects regarding dispute management from the perspective of the client. I am very happy to hand it over to Esperanza Barrón Baratech, who is an associate at the International Arbitration Practice of Latham & Watkins in Paris. Esperanza will be moderating the discussions this morning or afternoon. Esperanza, it is a pleasure to have you with us. Thank you.
Thank you very much, Anna, and good morning or afternoon, as Anna said, to everybody. I would like to start by thanking the organizers for this invitation, because it is truly a pleasure. It's also an honor to take part in this event, in this great event today. Thank you also very much for this opportunity to discuss the views from the client in international arbitration with such an esteemed panel of speakers. Because as practitioners, we work hand in hand with our clients, but we do not often take the time to reflect with them on our practice on international arbitration. So this panel is really a fantastic opportunity to explore what clients truly think of, and most importantly, expect from international arbitration and from its practitioners, whether arbitrators, institutions, or external counsel. So we will do that with 3 remarkable panelists that I will now introduce to you. So first, let me introduce you to Fabiana Leschziner. Fabiana is the Executive Vice President, General Counsel, and Chief Compliance Officer at Embraer in Sao Paulo, Brazil. So Fabiana graduated in law from the University of Sao Paulo before attending Cornell's LLM. So she therefore has dual training both in civil and common law, and she has a lot of perspective. She started her career as an external counsel in Davis Polk in the United States, and then she joined DuPont do Brasil in various senior in-house positions for almost 15 years. Afterwards, she moved to an executive role in Embraer in 2016. So in total, she impressively accumulates almost 25 years of experience. So we're very lucky to have her insights today. We will also hear from Eric Franco, General Counsel and Arbitrator at Engie Peru. Eric made the effort to log in at 6 a.m. From Lima to share his experience, so we thank him for that, of course. And Eric has an extensive academic background, having studied, among others, in Peru, Japan, most recently in England at Cambridge and King's College. He also began his career as an external counsel, but has acted as in-house since 2008, so that's a very long time ago. Eric first acted as in-house counsel at Alstom Power, then at a mining company, and he joined his current role as general counsel in Engie Peru almost 8 years ago. Eric has also acted as arbitrator and adjudicator for the past 10 years. That experience will also be extremely valuable for today's discussion. And last but not least, we're lucky to talk to Ignacio Zapiola as well. He's the general counsel and manager of international affairs at YPF in Buenos Aires, Argentina. Ignacio also has a dual training in civil law and common law, first from the University of Buenos Aires with a postgraduate degree in oil and gas law, and second from Colombia, where he holds a master's of law. Like our other panelists, Ignacio started his career as an external counsel in Pacbam and Krieu Gottlieb. However, he transitioned way later, after almost 15 years of private practice, and joined YPF as general counsel a little bit more than a year ago. So we will have as well a dual perspective from him. In parallel, Ignacio also teaches at the Universidad de San Andrés. So I will very soon hand back the floor to our panelists, of course. I just need to make a disclaimer before we start, is that our 3 panelists, our 3 speakers, will be discussing their personal views and experience, not those of their companies. and we will address various topics during this panel. For each topic, we will start with a short presentation by one of the panelists, and then we will have what we want to be an informal discussion, very open discussion with the other speakers. I have, of course, a lot of questions to put to them, but I do not want to monopolize the floor, and I really encourage the audience to participate. We want this panel to be very interactive, and I believe that you can do so in the comment section on YouTube, and that will be transferred to us, and then I can put the questions to the panel. So let's kick off the discussion with our first topic. Here we would like to question whether for clients arbitration is really the preferred method of dispute resolution. Because we often hear that international arbitration is the natural forum for cross-border disputes. But is that really the case? Do clients really believe that? So we'll hand the floor to Eric, who will now share his views on that.
Good morning, everybody. Thank you very much, Esperanza. I want to start thanking the organizers for this invitation. It's really a pleasure for me to be sharing this panel. And yes, well, to kick off with the discussion, the first topic is whether arbitration is still a preferred choice. I would say that, well, what we need to think is what is the other option, really. So the other option is courts. And in most parts of the world, courts are not that efficient. So arbitration is the best option available, really. So that's the starting point, really, to see it in perspective. There are some countries in the world where you can think about whether courts or arbitration are better. For example, in the UK or in the US. But in the rest of the world, really, well, with some exceptions, I think in general, arbitration keeps as the preferred option. The usual arguments to prefer arbitration are confidentiality, expertise of the arbitrators, flexibility of the proceeding, and also the enforceability of awards worldwide with the New York Convention. This is the main reasons that you usually hear. But I think you need to analyze this in perspective with the other option available. So what I see in the construction sector and in the industry, in the energy industry, is that arbitration is alive and well, and I don't see any challenge for this. In construction, I see there's a strong trend towards ADR, in particular dispute boards and adjudication. So I see this, and this is reducing the amounts of arbitrations where these ADR methods are being used. But arbitration, in case the dispute escalates, is still there. In terms of the parties' view about arbitration, I would say that there's frustration in general. And to see this in perspective, I think there are two things to bear in mind. First of all is that for dispute lawyers, it's very normal to deal with the proceeding of an arbitration or a court proceeding, right? It's very usual to deal with the formalities, with the way it works, with the due process and all this. But for in-house lawyers, there are some companies that are large enough and that have enough amount of disputes to have a lawyer dedicated just to arbitration or to disputes. But most companies don't have a lawyer dedicated to that. So the pool of lawyers is dealing with the day-to-day business of the company. And when there's a dispute, this is extra work that is not part of the day-to-day work. And it's more like a problem. It's something they don't like to deal with. It's taking time from the day-to-day work. So for in-house lawyers, unless they are just dispute lawyers, a dispute in general is something that is not like super fancy to do. It's more taking away their day-to-day work. And for the business people in the company, they just don't understand why a dispute is counted in years and not in months. Everything that is not in months is out of their mind. So there's frustration, and every time there's a jurisdictional challenge, there's a formal opposition of a witness, or there's a massive a request for the disclosure of documents that are confidential for the company. That is something like really business people don't understand, and they are frustrated every time they go to a dispute and have to deal with these kind of things. So we have to, I think, bear in mind the difference between the view from a disputes lawyer, from an in-house lawyer, and more from the business people that are part of the client. In terms of time, length, and in terms of cost as well, why spending money in something that is not part of the core business? It's very important to bear in mind that no company has as a core business dealing with disputes. The core business of a company is producing something or making commercial transactions. Something else is doing business, but having a dispute is not part of the business. So devoting time and money from their staff to deal with a dispute is taking the attention out of the core of the business. Then I think there's something also in the market that has to be, I think, discussed more and put in evidence. That is that external counsel and arbitrators are very busy, and there needs to be a fine balance, like to choose which work to take, which case to take, because otherwise everyone will be too busy to pay attention to the disputes they're working on. This could be related with the fees that are being paid. Maybe it's not enough, and there should be more for very complex disputes. I don't know. That's a discussion that needs to be in the table to go deeper. But arbitrators in complex disputes need to be available, need to pay attention to the dispute, need to be really involved from the outset, and the same for external counsel. They cannot have a lot of work, because otherwise the client will notice and will be frustrated as well with the process. Those are some general remarks to start with, Esperanza.
No, thank you so much. You've touched on a lot of points that I think we will visit with also the other panelists. And the first comment that you made is that in your sector, arbitration is present and is doing well. Is that also the case in your sector, Fabiana? How exposed have you been to arbitration?
First of all, I'd like to thank the Arbitration Channel for the invitation, and it's a pleasure to be here sharing the screen with you, Esperanza, Ignacio, Eric, and Anna. When you said that I had more than 25 years of experience, it was like a wake-up call. I've been around a lot, but this is I'm dealing with my first big arbitration, and I can say that one is enough. It's a lot of work. So my experience in my industry, of course, it's the aviation industry. There are a lot of arbitrations out there, but for me personally, this is the first big one. I haven't been in an arbitration that big, I think, throughout my career. It's almost 30 years. It takes a lot of time. It takes a lot of energy. And from an in-house counsel perspective, it's very difficult to navigate the details of the arbitration with with my colleagues, the other VPs, with the board of directors, the other business people inside the company. And I make also a comparison with Brazilian litigation. The companies here in Brazil are used to Brazilian litigation. And in Brazilian litigation, you know what to expect. You know it's going to take a lot of time, but you know that you're not going to spend so much money. And usually you have a success fee arrangement with outside counsel. And it's easy to have a success fee arrangement because it doesn't hurt so much. You get the award and then you pay the chunk, like a percentage of it, to outside counsel. With the arbitration, you just keep spending and you don't know what's going to happen at the end of the day because it's an hourly based fee arrangement. And I think in addition to all the work that we're doing with the current arbitration that we're going on, I have the same amount of work internally to justify everything that we're doing and to calm down all the business people and tell them there is light in the end of the tunnel. This is going to be okay at the end. It takes a while because the arbitration is it's a moving target. And as Eric said, it's flexible in terms of timeline. So our timeline was already changed from what was originally set up. So it's going to take a little bit more time to resolve. But one interesting thing and a piece of advice that I give here to other in-house counsel when dealing, in my case, it's an arbitration arising out of an M&A transaction. I can't give details on the arbitration, but for those who don't know, we are arbitrating against Boeing for the termination of the acquisition of the commercial aviation business that we have. And it was a 1.5 year long negotiation. So negotiated for 1.5 years, the whole transaction. When you are negotiating a transaction, usually from a company's perspective, the last thing you think about are arbitration clauses, right? You have so much on the table and you have so many business decisions to make and you have so many different clauses and reps and warranties and covenants and the description of the business itself that takes so much time that when it comes to negotiate the arbitration clause, you simply put this at the end of the line, right? And from my perspective, looking in hindsight, I think there was a mistake because we never thought we would end up in arbitration. Nobody thinks, right? You're not entering a deal to break it up. But at the end of the day, I think the arbitration clause could have been better, I think, drafted. We didn't have a tiered arbitration clause. It was directly from termination to arbitration. We didn't have mediation or any other intermediate steps before going to arbitration. And I think even the choice of the arbitration forum, I think the choice of the entity where the arbitration would be conducted was, I think, rushed. We had so many deal breakers to take care of and so many issues to deal with during the 1.5 year negotiation that the arbitration clause was kind of just overseen. You know, it was in hindsight, I think we should have paid more attention to that. And now we're going to this lengthy arbitration that's going to take a lot of time. So my experiences in my industry, it's arbitration is usually what people do. I haven't seen mediation or any other intermediate steps with that. But I think they are all pretty big, pretty lengthy, and pretty costly. So I think that's my answer to you, Esperanza.
So that's a very valid answer, of course. And what I found very interesting in what you were saying is that in hindsight, you would have negotiated that arbitration agreement differently. And I was wondering, Ignacio, you were an external counsel for a long time. Do you think that, for example, if now as in-house you would have to negotiate an arbitration agreement, what would be your ideal arbitration agreement? What are the features that you would really not negotiate about? For example, Fabiana mentioned the choice of the institution. What are your expectations as a recent in-house now?
Co-panelists, thank you very much for having me. It's a pleasure to be here. And I also want to clarify that I'm not the General Counsel of YPF. I'm the Disputes and International Affairs Manager. I oversee, international disputes and international affairs, assisting the General Counsel. And arbitration clauses, I like working on those a lot. And it's a little bit based on the experience of things that could have gone better on prior arbitrations or experiences. You then think, well, next time I have to negotiate one of these contracts, I will do this or that, right? So I think one of the futures, perhaps the most important thing is to get the right institution for your case or for your potential case. So that's a very important thing. And of course, you need to negotiate it with the other side, right? So the other side needs to be comfortable as well. So I think there are at least 3 or 4 institutions that, generally work. And that, most of the time, that's already in the contract and that's sort of like well done, right? So we're an in-house counsel, add value to an arbitration clause. I think thinking about the things that are going to make the arbitration more expensive, For instance, if you are dealing with an international dispute, let's say you have, Embraer on one side and Boeing on the other side, it's very likely that you will have, documents in English and Spanish. So I think it's a helpful feature for the company, for both companies, in order to save costs, to agree in the arbitration clause that, each party can present evidence in either language, right? So, you avoid translations, which are not so expensive because of the cost of translating, but they are really expensive because of the cost of, international lawyers reviewing the translations to make sure that they are fine. That adds an additional layer of an additional layer of costs. About, tier clauses, they are sort of like two schools of thoughts. Some people think you can always negotiate, so, no need to put it in. In my experience, I think that, parties, when a dispute is brewing, are less likely to go talk to the other. In external firms, they want to litigate. That's what they do. They don't want to talk to the other side. So I think having multi-tier clauses, more likely than not, can make a difference and can help, break the ice and cause a discussion early on that would, save a lot of resources, right? And similar to the production of the evidence in either language, I think just thinking, making sure that whatever you say in terms of the qualities of the arbitrators, I think it's important that the arbitrator can be someone either from the civil law or the common law, or that speaks, or ideally that can speak more than one language. Because another thing that gets tricky, especially for Latin American companies, is that, most of the time business agreements are drafted in English. They are subject to New York, UK law, and then it's not the same to litigate, these large contracts, with a tribunal that more or less understands, sort of like the realities of your region or of your country, than to litigate that before an adjudicator that it's more immersed in a different culture, right? So similar to the evidence point, I think, making sure that the panel can be diverse in a way that you can have, a UK lawyer, a Brazilian lawyer, and maybe a Peruvian lawyer. I think that's helpful, and most arbitration clauses on the international setting for LATAM companies, oftentimes do not quite allow for that in the way that they are drafted. So I would think those are some of the most interesting features that an in-house counsel can check and see to make sure that they are, in there. And maybe let me just add one more, and like an additional one, which is, on some arbitration clauses, you can say that although arbitration is a chosen remedy, it's not the exclusive remedy if you want to get, injunctions from any competent court, right? So when you're part of a transaction in which you may need to get a quick temporary relief, I think in those settings, it's very helpful to have in an arbitration clause sort of like a non-exclusive commitment to jurisdiction of any competent court for preliminary injunctions. I think that's a helpful feature most of the time.
Okay, great. So I think that Erica would like to jump in, right? Probably on multi-tier dispute resolution clauses and DABs, I assume.
Yes, I would like to give an example of this midnight clause feeling, right? There's a distinction between project lawyers and dispute lawyers. And then project lawyers are negotiating the contracts, as Fabiana mentioned. They are spending a lot of time negotiating the contract and have all other things in mind. When a project lawyer comes to the dispute clause, if the project lawyer has the reflex that think that this is an important clause, will probably send the clause to a dispute lawyer, either internal or external, and ask, like, is this clause okay? And basically, when the dispute lawyer receives the clause, we'll check if there's something wrong with the clause, not if it can be improved. It will just check if it's okay. And this meaning probably the project lawyer also asks the dispute lawyer, change as little as possible, because we are in a very complex negotiation. Don't complicate things. Just tell me if something is wrong. And that's it. What happened to me one and a half month ago in September, was that I was negotiating a very complex contract for a wind farm. And we spent like 6 months negotiating the contract. We were very, very tired. We tried to close it in September. And then we reached the disputes clause. It's a very large international contractor on one side, a large energy company on the other side. And well, we had the reflex. This is an important clause. So they sent it to the dispute lawyer. Fine. I was trying to include an expert step, right? Not a dispute board, just an expert one. But including an expert is not that easy. Like including an ADR step is something that everybody is familiar with. Like it's good practice. It's good for the reasons that Ignacio just said. It's going to help you if you are in that position in the dispute and so on. But it's tricky as well. And for example, it would be a good idea to make reference to the ICC Expert Rules. And in the Expert Rules, there are 3 options. So you would probably want to go to the administered one, yeah, because, well, it's a long discussion, but you would probably want that. But then when you tell that to the project lawyer from the other side, they simply crack down. They don't understand. It's too complicated. You know, I was willing to spend like 2 hours probably with this clause, and we are spending like 4. It's too much. So let's just keep it simple. This is what happened to me in September, for example.
Did you manage to get that expert phase in?
We included it as an optional step, keeping it very, very simple. Not an administrative step that was mandatory. That was what I wanted to do, but no, it wasn't possible.
Okay. Well, at this stage, we have a question from the audience. I think that they were reacting to Fabiana's comment about the cost of arbitration and the fact that you can, in Brazilian litigation, take contingency. And somebody suggested what the panelists asked what the panelists think about third-party funding in arbitration.
I can answer that, and then I think my colleagues can complement with their personal views. We were approached by some funding initiatives, by some funds to fund the arbitration in the beginning. It's an alternative, I think, for companies who are really willing to go forward all the way through arbitration but don't have the funds, or that it's difficult to predict how much it's going to cost. I think it's a viable solution for some. We carefully consider that in the beginning. But when you have, I think, a fund partnering with you, I think you have to be open to different outcomes in the arbitration, right? And especially if you don't care whether you're going to have any kind of relationship with the other party at the end of the day. In our case, one of the main points of deciding not to go with the third-party funding is because we want to control the outcome. We want to be able to settle anytime if you want to, and we want to be able to continue to be friends with the other party, right? At some point, we are not. One thing is one thing, another is another, right? We are having the arbitration, but we're still in a very much, I would say, small industry in terms of partners, and we don't want, as we say, to break any eggs that you cannot put them back together. So we didn't even consider third-party funding because of these other aspects in terms of future relationships, future partnerships, and different things that may happen in the future. But I think it's a viable solution. And thinking now, again, in hindsight, about how much it's costing us, I think many companies that go through arbitration do consider third-party funding as a viable alternative because it is very much expensive. But you have to put all these things on the table when you consider, because I think the fact that you lose the total control of what you're doing in arbitration is a very important thing to take into consideration when thinking about adding a third party to the mix.
All right. I don't know if anybody else wants to comment on this question.
Yeah, I can complement very briefly, and I think it goes to the points that Fabiana was mentioning, which is, you know, your third-party financing contract needs to be negotiated very carefully, and it's very tricky to negotiate from a company perspective because the funder is doing that all the time, it has a lot of clauses that, it will claim those are standard market, and perhaps they are not so standard and not so market. And so, I would go as far as recommending that you engage independent counsel, someone different from the counsel, litigating the dispute, to just review that and be very careful in terms of what you agree with your third-party funder, because, it can get really tricky. And at the end of the day, if it's a large litigation, it's a financing contract for a lot of money, and potential, for if you win the case and you get, a big upside, it's a lot of money that will have to go to the funder. So, worth spending, some advance money in hiring good lawyers and negotiating that agreement very aggressively.
Those are very good pieces of advice, I believe. I think that we can now move maybe to the second topic. Of course, we can have a fluid conversation, but we wanted to discuss case management and how you team up with external counsel when you're in-house counsel. So we'll discuss the client's experiences and expectations, of course, when working together and creating a team. So Fabiana, could you share your case management experience with us?
Sure. The first thing I think is to say, you have to trust your outside counsel. And Esperanza, I think you're going to like my answer, because you have to team up, really trust outside counsel, and being in-house. I don't know, my colleagues, how specialized they are in arbitration. I'm not. I've been so long in the corporate arena, I became more of a generalist and a strategist than any kind of expert in any single area of law. So I have to trust 100% my outside counsel, and that's what I do. And I brought my counsel very early on in the dispute, when we were, when you're gonna end up in a dispute, right? At some point, it's not an overnight thing. At some point, like at several weeks before, you start to smell things. You start to feel that things are not quite as they should be. I brought my outside counsel right along when we first started to feel that something was going all right, that was going to be diverting from what we intended as a final result in our deal. And that was, I think, was the most, the rightest decision that we could have made, because my outside counsel helped us all along to start preparing for arbitration, to start carefully putting the documents together and doing things. And at the end of the day, I think it was a very wonderful solution. And I've been counting on my outside counsel since then, right? So we have a very, very tight team. So we meet on a weekly basis to get the status of what's going on. Even if we don't have anything that happening in that week, we still need on a weekly basis to talk strategy. Our outside counsel is very close to the whole team, internal team that is working on the arbitration. I have been engaging many of my business colleagues, not only the VPs, we have directors, managers, every single person in the organization that has something to say or some document to add has been working very hard in the arbitration. And I think that's the only way for you to properly strategize. You have to be close to your counsel, and you have to work as a team. It's not us and them. Outside counsel now is kind of part of us, part of our team. To me, that's the only way to make sure that the arbitration is going the right way. We keep informed, and that also enables me to inform my colleagues and the board of directors better. And one interesting thing, just to tell you what's going on, I ask outside counsel to every month prepare what I call arbitration in numbers for my colleagues. So every month during our management board meeting with my colleague, the VPs, I have like a 10-minute presentation where I show them in numbers what we've been doing. How many documents, how many pages, how many lawyers working, how many hours of work. And I think that helps people inside the company understand why we're spending so much on arbitration and why it's so hard why we are putting so much energy into this, what entails the complexities of an arbitration. Nobody outside our legal realm here has any idea of what goes on in an arbitration. And when I put these numbers on the screen, I can see the shock in their faces because they have no idea of what goes on behind, I think, the curtains there. And so I have to work very closely with outside counsel to get this together. And you have to trust 100%. That's my advice.
That is really interesting, and what I find particularly interesting.
I hope she's listening to this.
Probably, if not, we can send a recording. But what I found particularly interesting is how you mentioned that you had the intuition that this was going to end up in a dispute and that there was no room for negotiation, right? Because Ignacio earlier said that some mechanisms of dispute resolution can help without involving external counsel to sort of reach a settlement. I think that the only person that we haven't heard from about this topic is Eric, and I know you have a lot of experience in DABs and expert education. Do you think that sometimes it's better not to involve external counsel at these stages before an arbitration?
I first going to what Fabiana said, I fully agree with her. Like the work of the in-house counsel is really key. It's a team. The external counsel knows a lot about the proceeding and the strategy and how to present the case. The in-house counsel knows the story or needs to put together the story, put together the information, take time from people that is very busy, and you need to take time from them to tell the story, to give the documents, to search for emails, maybe that are very, very old. So this is a very important, work that needs to be shared, right? Instead of, I think it's always, in general, it's always good practice to involve an external counsel if you have a complex dispute in the early stage. That will be better, so you can know where you're standing when you negotiate a settlement. And I think it's very important to bear in mind also, for having the big picture, that companies generally settle. For a disputes lawyer, the only thing that a dispute lawyer works with is with disputes. But for a projects lawyer, it's projects and the business and the transaction. And the exception is to have a dispute. Like this is what Fabiana said. Like in all her experience, one big arbitration. This is also for me as in-house lawyer. The rule is to settle claims, is not to have a dispute, to have an arbitration. This is something to bear in mind. Then the likeliness of a settlement is very high, really. But for having a settlement, what I generally do when it's a complex dispute is to involve an external counsel to see how strong is my case, so I can see like how aggressive the negotiation can go and where to like go back or insist on a point. So I think in general, even if you are working with a dispute board or in a mediation, it's good practice to involve an external counsel. What Fabiana also said, that it's key to keep the commercial relationship. This is really the rule in every market. No market is that big that you can really don't care about breaking the commercial relationship with your suppliers and with your clients. You need to take care of those relationships, because no market is that big. And then you have to be careful a bit with engaging the right external counsel. The external counsel cannot harm the relationship. I see sometimes external counsel being too aggressive with the other party. For example, calling the CEO as a witness and really like telling the CEO that he's lying or that he's not behaving ethically and so on. And then you are breaking the commercial relationship. And you need to be careful with that kind of thing. And also, because for most companies, dealing with disputes is not the day-to-day work. There's also a risk that when you engage an external counsel, the in-house team disengaged with the case, and then probably you are asking for reports and so on, but you are not really engaged with the day-to-day work. Maybe you are forgetting that you need to keep a bridge with the other party, a commercial bridge with the other general counsel, for example, to always reassess the possibility of a settlement at every stage. If the in-house team is disengaged and they say, no, now it's in arbitration, I have nothing to do, that's being dealt with the external counsel, then you are breaking the bridge that will allow any settlement. And that's something you need to be very careful about.
Thank you very much, Eric. I also would like to go back to something that Fabiana mentioned about arbitration in numbers. We hear a lot of clients asking for numbers as well from external counsel about, for example, the chances of success. And that I understand is important to report to your board or to management about how you will, for example, quantify recoveries or how you will organize internally. I don't know if Ignacio, you've been confronted to that kind of request when you were external counsel, or whether now you have different thoughts about it now that you're on the other side of the table, about how feasible or realistic these assessments of chances of success can be.
No, yes, I mean, I guess what happens is that you go to the board to make a presentation, and the first thing they kind of want to know is, what's our perspective, how are things looking, and sometimes it's really not easy to say, like even as a former external counsel, you're still in early stages, you're developing the argument, so you cannot really come up with a precise number or even range. It's a very hard exercise, and sometimes as you develop the case, you come up with better arguments and you get more confidence and so on and so forth, right? So, and but still, you want to try to give your board or the people above you, some idea of how things are looking. So you go back to your counsel, and then it depends, what jurisdiction is your counsel from, the kind of input that they're going to tell you, right? So then you need to adjust for culture in a way, right? Because, a New York lawyer, will hardly tell you that you have a 98% chance of winning. They're always going to be, if they think you have a good case, they will tell you, like, I don't know, 60%, 70%, they're going to be more conservative. Maybe counsel in other LATAM jurisdictions, will tell you, 100% we will win this, right? And so you also need to adjust based on the source of the information, right? But it's always good to ask those questions, to have candid discussions about that and what's going to happen next, because especially when you work in companies that trade publicly, you always need to be thinking about the next step, what you need to do next, how things are going to develop, if things go one way or the other way. There's a lot of contingency planning, if you wish, and having an idea of numbers, of percentages, of as best as you can, right? And some of the and most of the time, or some of the time, the estimates that you come with are not quite reliable or like quite mature, but you work with what you got, and you need to push counsel to help you on that end.
Okay, so still on the topic of relationship with management and boards, all three of you have highlighted the fact that disputes are bad news for your business, and that is not anything that the management wants to hear. What is your experience advising management on whether to start either an arbitration or a dispute? Do you feel like there has been some reluctance and that the goal is always to settle, or on the contrary, from, for example, operational people, you've heard something become very personal and you have been the one having to sort of stop them down? I don't know if Fabiana, you want to talk a little bit about the hurdles that you may face from inside.
Yeah. So I think you touched the neuralgic point here. I want to say the goal is always to settle. Yes, I think especially the board, and I think the leadership has they have the intent to settle as soon as possible. They hate any kind of form of either arbitration or dispute or litigation. They just want to make peace and get it over with. And I think it's a very consuming and time and energy consuming job to tell them, like, stick with me, wait a little bit, because even for a settlement, you have some ideal idea of like time frames and ideal windows for settlement. And when it's not the time, it's not the time, right? And I think, as Ignacio said, when there is so much still being done in terms of document production, submission, preparation, and everything, it's not time to settle. You're still trying to see where you are and what vulnerabilities you have and what strengths you have in the arbitration. So it's too early to settle. So we have to constantly keep pushing back internally and telling them, you have to stomach this, right? That's the verb. I think that's the word. You have to stomach this. And business guys want to get it over with. They want to settle, get whatever result they can as soon as possible, and continue with our day-to-day business lives. And it's a struggle. And I think one of the good things here as general counsel is that we are a very tight team in Embraer, the leadership, and we are all very much strategic, and we all think about the good of the company. I'm not a legal only or compliance only head, right? So we discuss a lot business, we discuss results, we discuss everything. So I think we have now reached the maturity at Embraer as leadership that we all know that we have the business mindset to decide what's best from a business standpoint. So I hope they don't think, and I think they don't, that's the lawyer talking. No, that's the businesswoman talking. So that's I think the only thing, that the level of trust that we achieved, it's the only thing that I think makes it better to convince. But usually that's what they want. They want to settle, and then they want to get on with our lives. And we have to, that's what I'm constantly doing, showing the timeline of the arbitration, showing when I think would be better positioned to think about a possible settlement, and when we will know what we have in our hands after document production, because I still have to see what documents we receive. And this way, I can, I think, bring them on board. But it's a very time-consuming and a very delicate balance between convincing them what's right, and appearing to be someone just defending the arbitration per se. So it's a very, I would say, political arena internally to deal with.
All right, it seems like it. It seems like a big hurdle. And going back a little to the relationship between external and in-house counsel, all three of you have flagged the importance of being a team. So I understand that everybody's on the same boat, but when and that you would say that, for example, in-house counsel should be more the co-pilot than the passenger seat. That's my understanding on your three interventions. But in practice, in order to be efficient and to really be involved, when do you think that in-house involvement is the most important? Is it at the outset of the arbitration? Is it, for example, to review in detail the written submissions? Is it before the hearing? Is there an ideal moment for or a critical moment where in-house should really monitor external counsel? I don't know if Eric, you may have some thoughts about it, or Ignacio.
Well, I think it's important to be engaged all along the process. At the beginning, of course, it's more important because the quality of the information you give, the quality of the story you tell as a company will define the case, right? So at the beginning is crucial. And then all along the proceeding, like being in the hearings for sure, like reading the main memorials is key, because you need to control like whether there's something that is incorrect, or maybe there's something that could harm the relationship. Maybe it's good for the case, but it's not for the relationship, or for you as a company in the market. You don't want to say something that it goes against your general strategy in the market, for example. So you need to check that, and that's a feeling that is not within the external counsel, that's within the in-house counsel, and you need to keep an eye on that. If we link it with the discussion that was being addressed previously by Fabiana about settlement, I would say that settlement allows thinking out of the box, and probably settling this dispute, a particular dispute, leveraging on future commercial work, more contracts, or with other disputes. That's something you cannot do within an arbitration or even in a dispute board, because there's always the limits of the boundaries of the pleadings, let's say, and that's the boundary of the discussion. But in the commercial transaction, there are no boundaries, so you can think about your commercial relationship as a whole, and that allows really gives ideas to settle a claim. I always have the idea that parties don't need an arbitration tribunal to tell them what is right and wrong. I think that if the CEOs of both companies have enough information, let's say, about the case, and they just not hear what the one party is saying, but they also hear what the other party is saying about the case, they would realize what is right. They could be arbitrators themselves. They could decide a case. So what I see is that for being able to reach a settlement, you need basically two elements. You need to escalate the dispute to the right level, so there's no conflict of interest, let's say. You are not in a fear of being fired from your work for admitting that you made a mistake. The right level. You just want to handle it in an efficient way. That's it. And also to have a good quality of information, not just hearing one party, but the other party. And if you don't have a multi-tier clause, that's very difficult to do in an early stage, because you don't want to show any weakness in your case. So you want to just show that you are very confident in your position. A multi-tier clause allows like hearing the other party, in a structured way. If you're not doing it at the beginning, then the opportunity you will have is at the hearing. Then the right people should be paying attention at the hearing to see whether they have a good case or not. And after that, really, you will have all the elements to settle the case. No? Well, a bit of the ideas. Mm-hmm.
I think, yeah. Sorry, Ignacio, did you want to jump in?
Yeah, maybe just to complement, I think, some of the places where disputes lawyers can put energy in order to have a more effective management of a company's disputes are, as we said at the beginning, at the time of drafting, and this is all in an ideal world. I'm not saying that it's always easy to do it, right? But at the time of drafting the dispute resolution clause, that's, energy put, there for the major contracts of the company. I think it's important, right? I think that the second moment that is quite important to focus, in-house energy is at the moment of hiring, external counsel. Great lawyers are not great lawyers for all of the cases. Some great lawyers are greater than others for some specific cases. So you need to make sure that you pick counsel that it's right for the case that you have at hand. And that takes a lot of time, because you need to reach out to different firms. You need to explain them, the dispute without, revealing confidential information, and just getting them engaged in some of the thinking, and all of that takes a lot of time. And sometimes you don't have that time, or maybe you didn't move that quickly and you are rushing, right? But I think that's an exercise that it's worth investing, significant in-house and even business resources, in order to get the right counsel. The choosing of the arbitrators, I think it's another stage where you want to make sure that whoever you choose and whoever, your party-appointed arbitrator is, will have, some role in choosing the chairman and in choosing, and in getting along with the arbitrator that has been chosen by the other side. I think it's important to try to choose someone that will understand your company, that will understand the perspective of your company. And this takes me to a point that it's similar to the one that Eric was making, that, I guess, always in-house, you are litigating and you're pushing because you believe that you are right? So it's very important to get your facts right, to get your chances right. And so an area where I think it's worth expending significant resources is just, trying to put on paper, what's your perspective on the case, the client's perspective, to make sure that along with the legal strategy, you come up with your best sort of like succinct way of explaining why is it that you are right. And if you have that, it's going to help you, choose counsel better, choose arbitrators better, and it's going to probably help you convince the other side that they should settle or that they should surrender sooner because you have your story right and tied and drafted up in a persuasive way. So I think those 4 areas are the ones where I would choose to invest, energy in comparison with others.
And we were mentioning the hearing as well as sort of a crystallizer of the parties' position and whether it can trigger something. We see some clients asking for mock hearings when we hire mock arbitrators, and they have members of their board or business people attend the mock hearing. That is helpful when you're an external lawyer, because it helps you prepare and really get to the hearing in a much better stage. But do you think that may be a helpful tool? Do you think that, for example, your management would be open to that, or is it really worth the cost in your opinion? Because of course it has a very high cost.
I never have done one, I'll be honest about that, but I would love to. I would love to see my case, play out with sort of like mock arbitrators or a mock judge, and just go through the whole thing, because when you do something for a second time or a third time, you just do it better, right? So
absolutely.
So just going through the drill. The challenge is that it can be really expensive, and people will need to be very committed to really take the role very seriously and to pretend it's real. But it's something that I'm eager to test and to do, because I can see a lot of value in having my counsel, when it's doing it for real, that it's not the first time that it's doing it, that he or she have already argued the position, dealt with the difficult questions, and now he or she are doing it again, having done it before. So I love that idea, but the price can be prohibitive, I think.
Yeah. Fabiana, is that something that could be done in your big arbitration, or you can add more cost to your board right now?
Yeah, in fact, I haven't thought about that, and I concur with Ignacio. It sounds like a wonderful idea, but if it's too costly, I don't think my board or the management will look at it with good eyes. But as a counterpoint to it, I think it's good, because cross-examination must be very difficult for executives, right? For just the idea of sitting there and being cross-examined, I don't think it sits very well. But on the other hand, I think you miss that first instinct of response. And what I like about our management team here is that they were all very hands-on during the whole transaction, not only the negotiation of the agreements. We had a group, it was not only conducted by lawyers, but by in-house. So the business guys were very much into the negotiations during the year and a half. We had a pretty tight team. And after that, we had 1 year of carving out the business that was going to be sold, and everybody was pretty much hands-on throughout the time. So I think they're eager to speak, if you think about it. And I think on the one hand, it's very good to have the mock hearing, because I think you prepare people better. But on the other hand, I think you may lose this human aspect of having the first instinct and have an open heart and say what's in your mind. And I think you have you have some advantages about that, because if you think about, we are all human beings, and if you put an executive there who has been throughout the whole thing and is very frustrated with the outcome, I think sometimes you get the energy of a person being able to just make his point in there. So I think there are benefits and I think pros and cons of doing that. And if it's too costly, I will have a difficult time convincing my guys that it will be done. And I think they're courageous enough to say, no, let me go there. I'm going to be trained previously by the lawyers, and I'll just sit there and open my heart. That's what I think is going to happen.
So not necessarily worth it, of course. Just one last point. Sorry, Eric, did you want to jump in?
Yes, I fully agree with what has been said. I think it's important to, in general, it's important to refresh, especially depending on the case, right? In some cases, you don't need to refresh much, but in other cases, you need to refresh to be aware of your weaknesses of your case as well, and to realize beforehand, and that's important. It comes to my mind with this kind of mock cases, an ADR tool that is, I think it's amazing. It's called a mini trial. It's basically like doing a mock hearing, but with two high management members from each party. It can come with an additional, let's say, person you want to invite to the mock tribunal, let's say, and both parties presented their case to these high management members. If you do it early on, before the arbitration, and it's confidential, it cannot be used later on. It really, it makes what I just said, makes the management realize the weaknesses and the strengths of the case, and it will end up in a settlement. It can be done in a very structured way. I've never seen it done in a structured way. I always seen it done in a much more informal way, and not such like a formal meeting. But I've seen management really hearing the other party's view in a meeting, for example, and this really increases the chances of success of settlement a lot. So, well, it comes to my mind when I hear about learning about the weaks and the strengths of your cases, and reviewing them periodically.
Have you seen that a lot? Is that something that is relatively common, the mini trial scheme?
No, it's not common at all in a structured way. Never seen it. But in an informal way, I've seen it several times. Management paying attention to the arguments of the other party. And that's something you really need to encourage. So if you have it as a step in your clause, or if you encourage it as a party, and the other party is open to do it, I think it really increases significantly the chances of settlement.
Excellent. Thank you very much. I think that it's time to move on to our next topic, which is the role that you as clients may have in shaping the future of arbitration or dispute settlement in general. So the idea is to discuss issues such as diversity, of course, but also creative ways in which you can increase efficiency, both in terms of cost and duration, because as we see, it's a common, it's a recurring topic that comes up when we're discussing arbitration. So Ignacio, you mentioned that you had been giving some thoughts to this issue for years as an external counsel, and now that you joined the other side of the table, maybe you can give us your 360-degree view on how in-house counsel can and should shape the future of arbitration.
Yeah, so the first point is to try to assess, is arbitration good as it is right now? Are we in a good state of arbitration, right? And when you group up with practitioners and with other folks in the field, you always complain about this, you complain about that. But I think, truth be told and fairness be had, I think arbitration overall works pretty well. Disputes get resolved. They take long, they are expensive, granted, but I think you have, with the arbitration system and with the role that some institutions do, I think you have a quite reliable system of resolving disputes that works in a globalized world, and provides a neutral forum, for people doing business from different jurisdictions, right? So at least in my assessment, I think we are in a good place. But it's always good to think, what can we do to make the institution of arbitration better? And in that question, what can the client do, right, to make it better? I think that from a client perspective, a generally perceived thing that could be improved in arbitration is that oftentimes, or some of the arbitrations awards that you get are not as sharp in the law or as fair, if I may, with the outcome. I think it's common to see arbitration awards that are a little bit of a compromise between the three arbitrators, let's say, and when you are litigating in courts, with a judge, typically, you know, the judge just tells what the law is, or the appeals panel just tells what the law is, and you typically get a more candid, a more honest, a more, you know, sort of like tough judgment many times, you know, especially if you're the losing party, right? But I think arbitration could get better in that sense, you know, having, you know, less compromise and more real law, if you know what I mean, you know. So that's one thing that could, you know, get better. Another thing it could and it should get better. It's how long it takes and how expensive it is, you know. And I think on this point, you know, there's significant stuff that can be done, especially pushed by the client, who is the one who is sort of like footing the bill at the end of the day, you know. And perhaps another area where we can improve is in diversity, and especially, you know, sort of like gender and age diversity in terms of nationality of the arbitrators or cultural background, at least, you know. And I always practice in the LATAM, in the Latin American region. I think we've come a long way. You know, I remember the early exit cases, you know, they were mostly resolved by, you know, Anglo-Saxon sort of like arbitrators, you know, male Anglo-Saxon arbitrators. I think nowadays, at least we see, you know, a higher component of non-UK, non-US, you know, and non-European lawyers, you know, being active in those panels. So I think on the diversity front, we've made some progress. We can definitely do more. And then, you know, it takes me to what can the client do on these fronts, right? And I think in terms of you know, in terms of diversity, gender, and age, you know, of course, appointing, you know, and choosing arbitrators that are younger and that are more diverse in terms of gender goes a long way. But it's also important that it's done in tandem with the institutions, you know, or with whomever is going to appoint the chairman of the panel, because sometimes, you know, something that I have seen, you know, counsel express when you press them in terms of, you know, let's get someone young, you know, let's get a woman on the panel. They say, you know, we do that, but, you know, you need to be mindful that, you know, you might get a chairman appointed that is very senior, that is the old-fashioned way, you know, and you need to have someone that can interact with that person effectively. And, you know, if the other side appoints, you know, a very senior person and then the chairman is very senior, you know, they are more likely to get empathic, right? But again, on this area, some institutions, I think they're going a long way in trying to, whenever they have to appoint people, they appoint people that are more gender and age diverse. And so I think that thing is moving away. Maybe the client should insist more that, you know, say that, you know, we clients are willing to do appointments of younger and more gender diverse folks, but, you know, the institution needs to also trust, you know, younger and more diverse chairmans for the panels. In terms of cost and length, I personally think that it's just, you know, and I don't have the solution, but I just think it's a little bit insane that we take so long to resolve a dispute, right? Sometimes, you know, you have a dispute that revolves around where the clause says A or says B, right? Or it means A or it means B. And you spend, I don't know, 3-4 years litigating that. And it's insane, you know, like entire cities can be built in 3 to 4 years, you know, like some of the world's greatest wonders were built in less time than that, you know. So like, is it really reasonable, you know, for the legal community, you know, to take 3 or 4 years to get to a definitive idea of what clause X means, you know? And I think the answer is no, you know. So the question is, how do you make it quicker and faster? And there, again, I don't have the solution, but I do think that, you know, briefs should be shorter, you know, like this thing with arbitration where you have like 500-page memorials, it ought to be just, it's insane, because like people cannot even read them these days with all the distractions they have and the distractions, you know, that they are tempted with, right? And, you know, we litigate a lot in US courts where there are like very strict page limits for very important issues, you know, like, and you're confined to, I don't know, 12 pages, you know, or X many words, and it works, right? So I think, you know, maybe something that at the early stages in the arbitration, if both in-house counsels want to save some money, you know, I think they can say, okay, let's agree on page limits, you know, or let's agree to diminish the number of submissions. You know, the other obvious area is, you know, document production. You know, document production is out of control. You know, people ask for way too many documents. You know, for the arbitrators, it's kind of tough to rule out and deny some of their requests because, they want to make sure their award is enforceable. So they don't want to be, challenged. They don't want their award in the future to be challenged and to be sort of like criticized for not having, considered X or Y evidence. But there, again, maybe we need to do something just to, and I think there's some efforts in progress just to limit the amount of discovery, because you spend as in-house counsel or companies spend, increasingly higher amounts in sort of like the key PMGs of the world in terms of, hosting fees, the data processing fees, collecting fees, it's pretty, it's pretty out of proportion, and you don't want, you want your resources being invested on what, goes to winning the case and not in just producing, paper that then an army of lawyers will have to review. And I think with that we've covered a fair amount of things that could be better. Perhaps another area is that, and for this you need to compare it with other judicial systems, right? But in arbitration, all of the issues get decided together at the end. And if you think carefully about that, I don't think it makes a lot of sense, because do you need to resolve jurisdiction and the merits at the same, and maybe merits and jurisdiction are not the best example, because you do have bifurcation of proceedings, and it's not uncommon that there's first a decision on jurisdiction and then on the merits, but there are still a number of cases that decide both issues at the same time, or that they decide other major issues at the same time. And I think if you escalonate like the issues, the order in which some issues get resolved, you might get a more efficient and a faster and a more cost-efficient process, because you don't need to get all of the issues till the very end, right? So that, I think that's another area where maybe, when you negotiate the terms of reference, or at some point say, okay, why don't we first decide, whether this agreement is enforceable or not, and once you have a decision on that, well, maybe then you enter the other discussion, or maybe you first decide on liability and then you discuss damages, right? And maybe it could also be that takes longer, but it's less expensive, because if you win in liability, then just you wouldn't have had to hire 4 or 5 experts to get to the quantum phase, right? So I think those are areas where more thinking could be done, and I think clients have a role to play there, because in a way we are closer to business people, and to the dynamics of the new methodologies, the whole agile movement, and maybe we can cross-contaminate the legal community that is always a little bit more behind than the business sector in adopting sort of like new ways of getting work done.
I think you were very modest, because you started by saying that you didn't have solutions, and I think you suggested a lot of very viable options, and I could not agree more with what you said. And here I encourage the audience to please chip in, because I think this is a topic where we could benefit from some input. So jumping on all the topics that you mentioned, so you started with the lack of assertiveness of certain arbitral tribunals, the fact that sometimes you have the impression that it's a Solomonic decision. I don't know if Eric, you've had this same impression. Would you do you think that is not something that you would see in a DAB, for example, or in an expert determination, more assertiveness?
Yes, I agree with what Ignacio is saying. What I've seen in expert determination is, it just you go to the point, no concessions made. In DAB as well, what I'm seeing is no concessions made. Like you just rule what you have to rule, and that's it. In arbitration, there are other considerations. You try to split the baby and so on. I see more that trend, and I fully agree with Ignacio that what the system needs is just clear cuts, just to say what it has to be said. And there's a losing party, there's a winning party many times, and just say it. Allocate the cost accordingly as well. So yeah, I agree with what Ignacio has said.
And do you think that a solution would be, for example, to have more sole arbitrators than 3-member panels, so that there's less compromise and maybe more assertiveness?
Well, of course, having a sole arbitration reduces the risk of compromise, but I think in complex dispute it's also a good practice to have three, because three minds think better than one, as long as the three minds are thinking and not just one. And yeah, so I think in complex dispute it's good practice to have three still. So the challenge will be to convince the three not to together to compromise.
And Fabiana, in your big arbitration that is going on, do you have also a 3-member panel?
Yes, we have a 3-member panel. I agree with Eric. We say safety numbers, right? I think they think better with 3 heads than just having one. I think the beauty of the arbitration lies in the fact that you can choose experts in the subject matter, as both my colleagues were saying here, that, for example, in our case, we looked for an arbitration panel that was very much knowledgeable on M&A disputes, international corporate M&A disputes, and so forth. So I think that's the beauty of it. But hearing Ignacio talk, I think especially the latter portion of his answer, I think he got in my head here and translated exactly what I was thinking with regard to the number of documents produced, the number of pages in each brief and submission, the number of document requests, and I think the only thing I think arbitration is very good. It's a very viable solution, but I think it takes too long, and I think it's too complex in terms of the effort you put into it. And Ignacio said it perfectly. I think the parties should have a way to determine a limit to number of pages, a limit to number of documents, a limit to number of exchanges, and so forth. When you don't have this, that's when costs escalate, and that's when you get frustrated with the amount of work and the pile of documents that you have to produce. So I think going forward, I think one of the things that we should do, or the arbitration community should start working on, is simplifying the processes. We have at Embraer, one of our cultural pillars is treat complexity with simplicity. I think that should be applicable as well to arbitration. It's very complex, but I think there are ways to expedite, to simplify, and to make sure just that get to the point without having this humongous amount of work in terms of document production and the brief preparations. On the other hand, I think some parties, and I say that very generically, but I think in arbitration, and some parties have the resources to spend on that much, on the amount of documents, and to the detriment of the other party in the arbitration. Sometimes the other party doesn't have the resource, and that's when third-party funding gets in. But sometimes the other party doesn't have the resources, so it becomes a weaker party in the arbitration because it's too much. So I think there is an advantage when the party has the money to spend on all this and the other doesn't. Right. So I think if you simplify the processes, you put both parties in a equal level playing field, much more than what we have today.
So we have spoken about extremely long submissions, document productions. Then we also have the issue of the awards that sometimes exceed also 300, 500, 700 pages. There's a lot of discussions among the community as to the fact that arbitrators do not really draft their awards. They always have secretaries or assistants that help them. Do you think that as parties you would prefer a simpler award but drafted by the members of the tribunal, or are you indifferent to the fact that sometimes maybe tribunal secretaries or simply associates or interns of the tribunal may have been drafting the award that you would have received? I don't know who wants to jump in, maybe Ignacio or...
I am of conflicting ideas on this point, because on the one hand, when you go to hearings and you see lead counsel on both sides, and these are like these, senior people, very experienced. and they have like an army of more junior partners and counsels and associates, you know, and you see, I don't know, 20 people on one side, 20 people on the other side, perhaps even more. And then you see just 3 arbitrators and perhaps a secretary. I always think, you know, this is unfair on the arbitrators, right? Because those are the guys that have the most important job, which is, you know, judging this in a fair way. And they seem to have the least of resources. And also economically, most of the time they get, you know, compensated to a lesser extent than the big important partners on the side. So I'm sympathetic to arbitrators perhaps needing more resources and making that more express, you know. But at the end of the day, and this is what I said, I'm conflicting ideas. At the end of the day, you know, you want a decision that is drafted, you know, or maybe not drafted, but at least, you know, mentally drafted by that person, right? You don't want him to outsource that, right? So what I would say is that, you know, I think arbitrators should probably have, you know, more resources, and that it should be okay that they get or that engage more resources. But pretty much like judges, perhaps in the US, you know, it would be great if they were more involved in the key parts of the judgments, right? And much of the length of the arbitration awards, it's content that is not really that helpful. You know, it's like it's in there because, you know, they want to prevent a potential argument that, you know, some argument wasn't considered. But at the end of the day, it's just a long recitation of X party said X, Y party said Y, you know, and, you know, just in terms of trying to have creative ideas on how to resolve that. Maybe that initial part could be something that the parties draft, you know, and they say, okay, we all agree that we made these arguments, you know, these arguments have been considered by the arbitrator, you know, and now comes the part that is drafted by the judge. It's just a crazy idea I'm putting on the floor right now, but just to, you know, get rid of that, you know, or to make it a more consensual thing, it could be more effective both at the time of enforcing the award and in terms of getting the arbitrator to focus on what really matters, which is, you know, the legal justification of whatever it is that he or she is deciding.
Absolutely, absolutely. We now have a very good question from the audience, and I know that Ignacio already gave his comments on that. But they were asking, what are your views on the participation of in-house lawyers in choosing a co-arbitrator? Should the law firms consult the clients with options or inform their suggestions? So I know that Ignacio mentioned that there's a discussion with external counsel. I don't know, maybe if Eric or Fabiana want to give their views on how involved in-house counsel really is or should be in the appointment of arbitrators.
So my question, I think, and then Eric speaks. As I said before, we need to trust outside counsel 100%, and I'm not specialized in arbitration, so I rely a lot on the suggestions of outside counsel. But the good thing is that outside counsel usually, in my case, shares everything with me and with my team. So we participated in the whole process of choosing the co-arbitrators, but we relied a lot on the suggestions of outside counsel. It was a team, I mean, in-house and outside counsel, a team effort. But at the end of the day, I agreed with the suggestion of outside counsel because they know more than I do, right? But it wasn't something that they just pushed on me or my team. It was something that was heavily discussed among us, and I was very grateful because we discussed in detail, and I happened to be informed of the profile of arbitrators that were in the short list and their experience, backgrounds, and everything. So I think information is key here. Communication is key, but at the end of the day, I think outside counsel knows better than me, at least.
Eric, do you want to share your views on this as well?
I fully agree with what Fabiana has said. I cannot imagine a case where the external counsel decides on his own. It has to be consulted for sure. Starting with the conflict of interest check. The party needs to check whether there's a conflict of interest, maybe not with one entity, but with a related party or whatever. So this has to be checked from the outset. Then all the other considerations, right? I can only think that it has to be consulted.
And in those consultations, is diversity a consideration for you, or is it not important? Ignacio was mentioning the fact that there's efforts. Sometimes you ask for gender and age diversity. Are those conversations that you're also having with external counsel on your end?
Yes, and this takes to a wider discussion that I think is very important as well. COVID and pandemic has changed a bit the dynamics of everything. So that's an interesting thing that has several implications in many things. And then ESG within companies, the care for the environment, sustainability, and governance. I think it's now it's taking a big part of our time for every company in the world, like every large company for sure. And one of those aspects is diversity, also greener arbitrations. So those are things that people is starting to consider. I think it's not really in every company, but it's increasingly being present. And then gender diversity, for example, I think it's something that is not always considered in the market, but things like the Equal Representation Pledge, for example, is important for people to think that they have to pause, think about diversity, and then continue. The driver of force is always you want to appoint a person that can have a better, I don't know, that you think that the view will be more favorable to your case. So you want to win, right? That's on top of diversity. But pause and think about it, right? I think it's not really extended in the market, this practice, but things like the pledge is increasingly making people think about it.
What about you, Fabiana? Were those considerations that were important when appointing arbitrators or even external counsel?
Yeah, no, there were important considerations. I really do pay a lot of attention to diversity, especially being a woman, but not to the detriment of the technical expertise of the arbitrator. So I would never choose just for the sake of diversity, right? A young lawyer or a non-US or non-UK lawyer or a woman just because I need diversity in a panel. I think first and foremost, you're looking for the technical expertise that you need to make sure that you have a fair decision at the end of the day, right? And if you can have a diversity with that, then yes, we look for diversity. And we have a very diverse panel, by the way. I would say very, very diverse panel, both in terms of gender and nationality. So I'm very happy with them.
Well, that's rare enough to be to be pointed out. And maybe we have time for maybe one quick consideration. It's a transition on what Eric was saying about greener arbitration, etc., and the impact of COVID in our practices in arbitration. We see more and more remote events. For example, this one. As clients, there's something that you really think you should do in person? Are you, for example, willing to have remote hearings for every type of hearings, or do you think that really there is some value to in person?
I can go first.
Yeah.
I think there are a lot of things that can be done through the internet, and it's fine, but just sitting down with your lawyer, discussing for 2 hours, taking a coffee break, chatting about another thing, going back, discussing again for 2 hours. I think you can, get through or achieve breakthroughs that you cannot do through a screen, because like when you're on a screen, you don't have the person's full attention. He might get distracted with his phone, with someone on the background, he knows he has to run to some other place. So, like for certain things, I like going to where the lawyers are, or I like the lawyers coming to where my team is, and because I just force them to be disconnected for the other things that are competing for his attention, right? And so I think, when the budget allows, doing things in person, some specific things in person, not all of them, it's a plus.
I don't know if anybody else wants to comment. We have 1 minute left, I think.
Okay. Yeah. No, I agree with Ignacio. Although I think online works so well. We've been outside of the office at Embraer for 20 months now, and I think we managed to turn the company around after COVID and after losing the Boeing deal. The company, I think, was turned around. So you can be effective online, and I think you can work. But I agree with him. Some face-to-face are irreplaceable. Some face-to-face interactions are replaceable, and I hope they come back slowly to the interactions face-to-face. And they are more productive because you get everybody, the whole team together in a room, and I think you can work more effectively.
Like from my perspective, the challenge is really going to be how to make hybrid sessions effective. Because if we are all on the screen, it works. If we are all in person, it works. But the reality is that not all of us are going to be in person, and not all of us are going to be on the screen. And that's where I think the technology is not quite there to make it the same, in an hybrid format, right? So that's going to be the challenge, I think.
I fully agree with what has been said. No, hybrid is going to be very challenging, and I think certain things are better in person, like hearings, for example, especially when there are witnesses or experts, especially witnesses more than experts even, and being able to present your case live is always better, I think, than on a screen.
Thank you so much. I think that, we're 1 minute late, so I think that this counts as being on time. Thank you so much to the three of you for all your insights and for your very honest answers. And Anna, we're handing the floor back to you. I know that you have a very exciting program ahead.
Yeah, thank you so much, Esperanza. Thank you so much for an excellent panel. I think it was just fascinating to hear your experiences and perspectives on so many topical issues. Thank you so much. And I think you're heading now to the panel 3, and hope you enjoy the event. Thank you.
Thank you.
Thank you.
Mm-hmm.